Hello and Namaste. I am Ketan Kank from 192 Consulting and I welcome you back in this series of question and answers. This is the second video that we are doing in this second series of question and answers, and we will be taking up next 3 questions that we have shortlisted for this series of videos. So the first question today that we are going to take up is, I have the share certificates, but those share certificates don't comprise the entire shareholding in the company. What should I do? In this case, it should be understood that the companies have stopped issuing share certificates, especially after the advent of or as per the provisions of Dematerialization Act. The entire shareholding has to be compulsorily held in the demat format. So, share certificates slowly and gradually are going to get redundant. There are certain share certificates which were issued in the previous era, but after that, if the corporate actions have happened, then it might happen that the shareholders are holding share certificates, but the share certificates or the shares mentioned on those certificates do not comprise of the entire holding of that particular shareholder in the company. There are two things, or there are two possibilities that can be imagined or envisaged over here. One, the holding of which the share certificates are not present, either the corresponding share certificates are lying with the company or the share certificates have been misplaced. In both cases, the shareholders are requested to correspond with the company and the RTA accordingly and verify the details of holdings so that the reclaiming procedure becomes hassle-free and can be executed in a robust manner. There are two different set of compliances if the share certificates are misplaced or if the share certificates are lying with the registrar and transfer agents or the company, as the case may be. The shareholder will have to follow the set of compliance as mentioned by the company or the RTA, but before that, it is imperative that the whereabouts of those certificates which are not there should be asserted. Either they can be with the company or they have been misplaced. Then the set of compliance has to be identified and the documentation has to be done accordingly. Next question. What if there are multiple legal heirs and all are fighting with each other? So this is strictly a family feud. This is strictly a family question. We actually don't get into this space or the family matters. It is advisable that the family members should come together, look at the larger picture. They should come to an understanding that the shares be reclaimed and then can be divided as per their understanding. Because fighting, the family infighting is not going to help anyone, but beyond that, we cannot suggest anything on this because it's strictly family matter and it is again advisable to come to an understanding and a family compromise. Next question is, in how many persons' names can a demat account be opened? Normally, a demat account can be opened in either one person's name, 2 or at the max 3 people. There are certain depositories who may allow the opening of the demat account beyond 3 persons also. But if we speak in strict reclaiming sense, then it makes sense to open a demat account as per the names mentioned on the share certificates or the other document which is being issued by the company. So it is suggested to the shareholders to open a demat account as per the names mentioned on the share certificates. If any person on the share certificate is deceased, then the demat account should be opened in the name of the other persons. So that was about demat account. Should you have any query, any question, issue relating to reclaiming of the shares, you may feel free to reach out to us. You may reach out to us through an email on info@192.in, or you can simply mark your comment in the comment section of this video. We will be all the more happy to help. Till the time, this is Ketan Kank signing off. Thank you so much.